1971 Bailey versus Cantou. Ms. Riley, I have reviewed the application and did want the opportunity to meet with you and the applicant. Um, the couple is residing together presently.
They are not, Your Honor.
Okay.
Respondent was arrested and taken to jail. There are bond conditions that say to stay away from Ms. Bailey, but we could not find an emergency protective order. And so that's why we went ahead and asked for the kick out. The arrest was March 7th, so we are within the 30 days.
Okay, fair enough. And I guess you've had an opportunity to talk with Ms. Bailey about safety planning and those types of issues.
Yes, Your Honor, not me directly, but members of our staff in going through the process of applying for the protective order. Our counselors do cover that. And certainly if Ms. Bailey had further questions and if the court was okay with it, if we could go into a breakout room after the actual hearing, then I can answer any questions she has from this point on or any concerns she has.
Okay, fair enough. All right, and let me just, I don't know if, yes, I think you did send the proposed order in with the application.
Yes, Your Honor, that email that our paralegal sent was in our original request. I believe it was sent at 10:33 this morning. It should have the proposed temporary ex parte order attached.
Yeah, I do have it. Just give me one moment to get back to it. Okay, and so we have a hearing already set on the 1st of April, requesting a permanent protective order.
Yes, sir.
Okay. And there's no divorce or sex or at this time?
Not at this time.
Okay. All right. Based on everything I've reviewed, I am going to go ahead and grant the relief requested. Ms. Bailey, do you have any questions or anything you need from the court or from Ms. Riley before I let everyone go?
No, I'm just grateful that you're able to do this for me, and then I can move forward with divorce and stuff. Just my safety and my children's safety was what I wanted to get set in place first, because I was concerned with that. So I really appreciate y'all's time and everything.
Absolutely. Sorry to meet you under these circumstances, and best of luck to you and your family. All right.
Thank you, ma'am.
Get the order signed, and we'll get that taken care of for you.
Thank you.
Thank you, Your Honor. And my office will forward a copy by email to Ms. Bailey once it has been processed and file marked so that she has that for her records in case she needs it.
Okay, great. Hearns. All right. Versus seeing nothing else. And Mr. Ilonsky, I've read the application, and let me turn it over to you to see if you have anything else that you would like to add or to update the court on.
Just a few questions, Judge. Ms. Hearns, since the time of the incident, has Mr. Hearns been charged with anything?
Not as I know of.
What about the original? Has he not been charged with assault, family violence?
Yes, since the accident, yes.
Okay. And by accident, you mean the incident at home that has made the basis of this suit,
Yes.
correct?
Correct.
Right. Now, you had mentioned also in your affidavit that there has been other times where Mr. Hearns had been violent. Would that be correct?
Yes.
Can you very briefly tell the court when that occurred and what happened, please?
This has been some years back, and I mean, he had a protected order. Then he did some classes. Then they can see when they pull it up that he have a previous record of family violence.
Okay.
So this is the second attempt for the family violence.
All right. So there was only one other incident aside from this?
Well, we had some more incident, but I never reported it.
Okay.
Yeah.
The incident, so can you just very briefly tell the court about those instances? Just what we need is a month and date and just kind of very briefly what happened, if you can remember.
Okay, probably about, I could say about 8 or 9 months ago. I don't really know what date it was. We had another incident, me and him, with his attitude, his temper is really, that's what's get us. He has a really bad temper when he gets angry and mad.
And did he assault you in any way?
Well, he pushed me. Actually, we pushed each other because when he pushed me, I pushed him back. I have been through this before. That's why I'm trying to, protect myself. I'm not going to let anyone just hit me, and I'm not going to hit them back.
Okay. Let me just clarify the previous instance for when he was criminally charged.
Hmm.
You were the victim in that matter as well.
Yes. Hmm.
I have no further questions at this moment, Judge.
Okay. All right. And where is Mr. Hearns residing in the residence as well currently?
No, he's not living here. He's got
Okay.
a protected order, emergency protected order against him right now.
Okay.
Now, I will clarify that, Judge, and what Ms. Hearns means is she's talking about the EPO issued by the criminal court, of course, but that is due to expire. And of course, we don't know if and when it'll expire, or rather, we don't know if the matter will. We don't know if the court will issue another EPO order or that there is a criminal court. So we're trying to pursue a civil protective order that will last Ms. Hearns a little bit longer than the EPO itself.
Okay. Understood. And Mr. Alonsky, I see, so there is also a companion case, a divorce case
Yes.
that's been filed.
Yeah.
And what are we thinking, the next steps for this? Are you setting temporary orders or you want a final protective order? What is the request as far as normally the protective order has a date and time for the next hearing, and I didn't see that in your proposed order. So let me know what the next step is that you propose.
Yes, Judge. And I do believe we did file a show cause um, with a blank line for a date and time. The way our office did it, I think we were trying to follow the new forms, and we might have not done it 100% correctly. But we had the ex parte protective order and then a show cause as a separate order, and we can file one that kind of combines the two if the court needs us to do so. We're just trying to go by the new guidelines, the state mandated order. With that being said, I'm sorry, state mandated uh, verbiage that the state wanted us to use for the protective orders. With that being said, Judge, we're not looking for any kind of temporary orders in the divorce. We're likely going to proceed straight to a final trial. And as for the protective order, I know we filed that separately this morning. I do not know. I do not know. My paralegal has not told me if it was put into the same court as the divorce case. Has it, or is it in a completely separate case?
Well, they're filed separately. The district clerk files them separately. So
Okay.
they are
Um,
noted as companion cases, but they're separate.
Understood. We're just hoping for a final hearing on the protective order, Judge. And for the companion case in the divorce, we'll be sending that for final as well, as soon as possible.
Okay. All right, then, Mr. Alonsky, what I need you to do is if you could get that hearing set with the court admin, the date and time, that comes from you and court admin. I don't pick a date for you. You have to call them and get a setting. So if you could email me the updated show cause order with that hearing date, that would be fine. Based on the evidence in the application and what I've heard here today, I will grant the application. And if you could just get us that date, we can get everything signed and taken care of for you.
We will do that, Judge, and we will combine the ex parte and the show cause together. Yeah, we will do that. So we will
Okay,
have that to you by the end of the day. Thank you, Your Honor.
great. Thank you. All right, Ms. Hearns, sorry to meet you under these circumstances.
That's okay. Thank you so much for meeting me too.
Sure. Wish you the best, okay? Take care,
Okay.
Smith B. Smith. Ms. Plumban, as your client, you may proceed.
Thank you, Your Honor. Good morning. Megan Plombon for applicant Mary Smith, and I'm filling in today for Mr. Justin Jackson.
Okay. And I've read the application. I just want to confirm a few things with you. You are asking for a kick-out order.
Correct. Yes, Your Honor. So we had a previous protective order that we filed and non-suited without prejudice in hopes that the situation with respondent would calm down, which unfortunately did not happen, and on condition that the respondent adhered to certain terms, such as not coming to the residence. And he has reneged on those terms. Now, we do have a Rule 11 agreement for temporary orders excluding respondent from this residence, but as seen in the affidavit, respondent has made threats and communicated to police his intent to go to said residence. So we would request the court to have this exclusive occupancy of the residence by applicant Mary Smith.
Okay, and I just want to confirm, have you and your client talked about safety planning given what is being requested of the court? I just want to make sure that has been discussed.
Yes, we have. Mr. Justin Jackson has discussed that more with her, and she has had conversations with the police officers involved about safety precautions, and they have given her advice as well in that area.
Okay. All right, and let's see, is the plan to come back and ask for a final protective order or temporary orders? What is the plan going forward?
We would like to go forward with temporary orders.
Okay. And is that something you have already set with court admin or plan to get set pending the outcome of this hearing?
We plan to get set that pending the outcome of the hearing.
Okay. All right. Let's see. Okay. Well, in light of what I have reviewed in the application and in the affidavit, I will grant the request for the protective order. And Ms. Plumman, if you would contact the court administrator to get that hearing date obtained and set with them, so we can include that in the actual protective order, so that date will be included as. Does that make sense?
I'm sorry, could you explain that a little bit?
Oh, yeah.
What
So
you're saying?
typically we include the next hearing date in the order itself.
Oh,
So
I see what you're saying.
that the respondent will be on notice, not only is there a protective order, but that he needs to appear at the temporary orders hearing.
Yes.
Okay. All right. Well, if you will get us that information, we will get the order entered.
Okay. Thank you, Your Honor. I just have one quick situation that I'm trying to square away. I think that we will also be requesting a full protective order.
Okay. Just contact court administration and you may set those on the same day. They may be different days, but if you will get the date and what is being heard and include that in this order.
Okay.
Makes
Thank
sense?
you very much. Yes.
Okay, perfect. All right. And seeing nothing else, y'all are free to go. Ms. Smith, best of luck to you.
Thank you, Your Honor.
Take care.
The notice of termination, I don't have it in hand, but it has been signed by both purchasers. I don't possess it, but that's the latest as of a few minutes ago.
The issues remain.
I'm just updating you. That's it. Just updating you.
Welcome to the 200th. We are here for an emergency hearing in Becker versus Up Equity. Council, you may proceed. These hearings are short. We've got a lot of other protective orders and TROs coming in, so I can spend limited time on the bench, so I can get back to reading those.
Good morning, Your Honor.
Morning.
We are here on an emergency basis because defendants have scheduled the sale of the subject property for March 31st, just days before the trial in this case. If allowed to proceed, that sale will permanently deprive my client of the very rights this lawsuit is designed to protect: his ownership interest and his equity in his home. We respectfully ask this court to grant a temporary restraining order and ultimately a temporary injunction to preserve the status quo and to prevent this out-of-court adjudication that would irreparably harm my client before he ever gets his day in court. Under Texas law, a plaintiff seeking a TRO or a TI must establish 1, a valid cause of action, 2, a probable right to relief sought, and 3, imminent and irreparable harm. We satisfy all 3. First, validity of the cause of action. Plaintiff brings claims for fraudulent misrepresentation, usury, violations of the DTPA, and breach of contract. At the heart of each claim is a transaction that defendants called a trade-up agreement, but that evidence shows that was actually a loan, a disguised mortgage where title was transferred not as part of a genuine sale, but as a collateral. Daniel Hernandez, defendant's own former head of mortgage, has submitted a sworn affidavit testifying that the entire structure of the trade-up agreement was engineered to evade lending laws, and that plaintiff was never supposed to lose ownership. This was not an arm's length sale. It was a financial product that defendants misrepresented from the very beginning. Second, the probable right to relief. Your Honor, testimony from defendants' current and former employees confirm what plaintiff has argued from day one. He never relinquished his interest in the property. Matthew Becker, Up Equity's former program manager, testified that plaintiff was supposed to retain ownership until the home was resold. This is so because even after the execution of the deed, plaintiff continued to be responsible for real estate taxes, property upkeep, insurance, and carry all of the obligations of ownership, including the repayment of the funds advanced by defendants. Under Texas law, if a deed is given to secure a loan, it's a mortgage, not a conveyance. Equity will look past the form and recognize the substance of the transaction. So while a deed was signed, it was under false pretenses, and equity treats that deed as a security interest, not a transfer of title. Lastly, Your Honor, imminent and irreparable harm. The scheduled sale on March 31st is not theoretical. It is real, imminent, and it is irreversible. If the sale is allowed to proceed, plaintiff will lose the very property at the center of this case. That is harm that cannot be undone. Texas courts have long held that real property is unique and its loss constitutes irreparable harm. There is no adequate remedy at law. No amount of money can compensate for the loss of this home, especially when plaintiff is trying to prove that the transfer was never valid in the first place. If the sale goes forward, there will be nothing left for the jury to decide. By closing the sale before trial, defendants will strip this court of jurisdiction over the very property in dispute, effectively securing the outcome they want without allowing the court or a jury to weigh the evidence. Defendants may argue that the lease pendants were dissolved. That's true, but those rulings were based on procedural deficiencies by prior counsel and the failure to proffer evidence in support of plaintiffs' then existing claims. And I have already acknowledged that before this court. This court has never issued any finding of facts regarding the validity of my client's claims over the property. More importantly, lease pendants and injunctive relief are not governed by the same standard. The former focuses narrowly on whether title is in dispute. The latter, what we are asking for today, focuses on preventing irreparable harm and maintaining the status quo. That is a different inquiry. Last but not least, the TRO is an equitable relief, whereas the lease pendants is not. Second, defendants may argue that plaintiffs signed the deed voluntarily, but testimony, including from their own personnel, shows that plaintiff did so only because he was misled into believing that he was retaining ownership and merely accessing equity. That deception is central to our claims and support the need for injunctive relief. Lastly, they may claim prejudice from the delayed sale, but a short postponement is far lesser harm than the complete loss of property my client faces. The balance of equities tilts strongly in favor of granting relief. Your Honor, I personally reached out to defendants' counsel and asked them to voluntarily postpone the closing until after trial. That request was denied. I reiterated the same request even this morning before this hearing. Defendants' counsel again refused to preserve the status quo and to wait the conclusion of trial before selling the property. Defendants' counsel submitted a declaration this morning that reports unreliable hearsay within hearsay regarding the status of March 31st sale date. Defendant's own employee declared that the sale is moving forward on March 31st, and the publicly available data shows that the subject property is active under contract. If the sale was actually canceled, the subject property status would not continue to be active under contract. We brought this motion promptly once it became clear that they intended to proceed despite the risk of rendering the trial meaningless. This is not delay. This is a last-minute sprint by defendants to shut down the case before it can be heard. Your Honor, this court has the power to preserve the status quo, prevent irreparable harm, and ensure justice is not overtaken by paperwork and deadlines. We are not asking the court to decide the case today. We are asking only for a pause, a brief window to allow the truth to be heard, the facts to be tested, and the law to be applied by this court, not by a premature sale. And for all of these reasons, we respectfully request the court issue a temporary restraining order and, following hearing, a temporary injunction preventing the sale of 8400 Denali Parkway until trial is concluded. Thank you, Your Honor.
All right, Mr. Silvestri.
Good morning, Your Honor. And I did submit a declaration to the court this morning with what I know about the sale. I have a further update in that regard. My understanding, I do not have it in my possession. If I did, I would put it before the court, but my understanding is that my client has received a fully executed by the former purchasers notice of termination of the sale. So I can only report to the court what I know. I've asked for a copy of that. I still don't have it from my client. This is obviously unfolding in real time, but I'm endeavoring to update the court and counsel the moment I have new information. So with that out of the way, let me address the arguments. The plaintiff is not entitled to a temporary restraining order for 4 reasons. First, this motion is untimely. It is gamesmanship designed to inflict maximum financial harm on equity. Second, plaintiff has no probable right of relief on his real estate claims, which this court, and in fact, Your Honor, has already determined with regard to his 3 lis pendens, which were expunged. Third, as of this morning, it does not appear that there's any threat of imminent harm necessitating a temporary restraining order. And fourth, to the extent the court finds there is likelihood of success on these claims, the balance of equities favors of equity, not the plaintiff. As to the timeliness and the gamesmanship, the first motion for a temporary injunction in this case was filed over a year ago, February 8th, 2024. I've put before the court, recognizing we put a lot of paper in front of Your Honor yesterday. Okay. Exhibit 21 to our response is my correspondence with not Mr. Natale, but Mr. Becker's former lawyer, trying to get that motion heard and briefed. And I received nothing. I followed up multiple times. It's not usual for the defendant and the target of a temporary injunction motion to have to schedule it. We received nothing. So that motion has been on file and not noticed for over a year. The second motion for a temporary injunction was filed on February 20th, 2025, over a month ago. Plaintiff tried to have that motion heard on an emergency basis. This is Exhibit 20 to the response. He was told no, the court does not issue temporary injunctions on an emergency basis, and he was told to notice it up in real on the normal central docket. As part of that exchange back and forth, Your Honor, as you'll see in Exhibit 20, we submitted a declaration saying this sale is not scheduled until March 31st. Plaintiff was in a position, as instructed by the court, to have these arguments heard before this sale was imminent, and he chose not to. What he did was he waited 33 days, knowing about this sale, and then he noticed up an emergency motion, this time for a temporary restraining order. And the reason he did that, Your Honor, is because that will inflict maximum financial harm on equity, because it would put us in a catch-22. We obviously can't violate a court order to not complete the sale, but at that point, our time to unwind the sale, let the purchasers know that a court is dealing with this issue, is gone. We would have to breach that agreement, exposing us to additional claims. Now, this all may be altered by the fact that the sale is not happening. I want to recognize that fact, but this is about the timeliness of this motion. This motion is before Your Honor on an emergency basis. It's within Your Honor's discretion to grant something on an emergency basis, and I would submit that this clearly manufactured urgency does not merit it. This is put in further context by the history of the lis pendens in this case, part of which Your Honor already knows about. You were the first judge to hear of the lis pendens arguments back in December. Back in December, Your Honor heard argument about disguised loans and mortgages. Mr. Natale recognized his client was at that time under an obligation to prove and I'm quoting from the statute now, probable validity of his claims to the real estate, his interest in the real estate. He failed to do so. Those lis pendens were expunged pursuant to 12.007 of the Texas Real Estate Code. Then Your Honor may or may not be aware, 5 days later after your order, he filed a third lis pendens, further locking up this property and preventing the sale. We had to have that expunged. And on February 20th, Judge Cantou expunged that lis pendens for the same reason. His failure to prove any real estate claims had a probable validity. And probable validity is an even lower test than likelihood of success on the merits. And all of the evidence before Your Honor, all 600 pages before Your Honor today, was before Judge Cantou. The deposition of Matthew Becker was considered. The declaration of Danielle Hernandez was considered, right? These are all legal questions for which lay witnesses do not tell the court what to do. So given that history, what happened is clear. First, plaintiff locked up the sale of this house using improper lis pendens, one of which was filed in secret, as counsel has acknowledged, and I will admit, not by him, okay, but by Brandon Becker. After all of that was exhausted, he turned to injunctive relief. That didn't work on an emergency basis, and so he manufactured an emergency for a TRO by waiting till today. So that's the timeliness argument. Your Honor would be well within her discretion to deny this emergency request based on timeliness alone. But let's talk about the second reason. Plaintiff has no probable right to relief. Plaintiff grounds his argument for a temporary restraining order and later an injunction on a single claim, the fraud claim, fraudulent inducement, misrepresentation, and his disguised mortgage loan theory. He treats them all as one argument. Okay. Those have all already been rejected on the same basis under a lower standard, but let's examine them. Okay. The relief requested in the fraudulent inducement claim, which is that this is actually a mortgage and that what he signed was a mortgage, even though it says deed at the top, but he's acknowledged it grants a full 100% interest in the property. Again, as your honor already knows from back in December, but the evidence is in front of you, right? And what that would mean under plaintiff's cited authority, Johnson v. Cherry, the decision from the Texas Supreme Court, when a court recharacterizes a deed as a mortgage, which obviously we don't think it should, but if it did, it would also, as instructed in Johnson v. Cherry, have to find that Brandon Becker owed all of the money back. Brandon Becker is not going to pay this money back. He was asked in his deposition if he's ever offered to pay it back. He said no. And I think the litigation history of this case and his claims make clear he has no intention of paying it back. And more to the point, Your Honor, this under Texas Code 680, this application for a TRO must be accompanied by verified declaration or a verified petition or a declaration. There is a declaration attached, Exhibit 1 to the motion for the TRO. However, that's from Brandon Becker. He does not say in that declaration, I intended to enter a loan. He hasn't said it in his deposition. He hasn't said it in declarations. What he has said is that I think I retain an equity, these are his words, equity interest. And what he means by that, as demonstrated in his deposition, which again, all in the papers, is he retains a right to receive money if there's a surplus in the sale. And Your Honor, we agree with him. That's the point of the trade-up agreement. If you can remember back to December, the point of the trade-up agreement is you sell us the house, which happened. He got $2.24 million for it. He paid off his first mortgage and then went and bought a second home, right? We'll buy your house. And then on a resale, you get the upside or you cover the downside. That's a contractual right under the trade-up agreement. That's not equity, but Mr. Becker's not a lawyer. He's not expected to know what equity means. However, the court knows what equity means. The court knows that equity, this is a pure legal question, which is why we're up on summary judgment this afternoon in this case. The equity means an ownership interest title, something like that. It's not a contractual right to receive money. Again, if this house sells for $4 million, Brandon Becker's getting the surplus, right? So he admits, I sold the home to Up Equity. He admits it like something like 17 times. Again, I think it's on page 7 of our brief. We have all the citations for you there. I sold the property to Up Equity. What did the deed do? It transferred 100% of the interest. It's all there, okay? So plaintiff's requested relief doesn't match up with what he's asking you to do. He's asking you to find that he's likely to succeed, that he has a real estate interest that this court has twice rejected under 3 separate lis pendens, okay? That's not something this court should do, nor is it required under Rule 680. If you're going to enter a TRO today, you have to find that he's likely to succeed on these claims that 2 times have been found to not generate real estate interest in the property. Plaintiff is not without remedy. His DTPA claims, his usury claims, his fraud claims, those will be adjudicated perhaps this afternoon. And if he wants money damages for those, and he's correct on those claims, he'll get them. He's not without remedy. What he's asking you to do is recognize a real estate interest that the court has already twice rejected. The court should not do that. It would, at a minimum, be inconsistent among those rulings. So Brandon Becker's made very clear, it's Exhibit 1. If you want the page and line reference, it's page 115 and 118 of Mr. Becker's deposition. He's not going to give back the money. He didn't intend to borrow it. What you have before you, Your Honor, is a real estate sale contract, a settlement sheet from a real estate purchase agreement, and a deed, right? Plus the trade-up agreement, which establishes some purely contractual rights between the two. But again, as I've already argued before, Your Honor, and I argued before Judge Cantou Hexel, that is not, the trade-up agreement is not an agreement for the sale of real estate. The sale of real estate is governed by the sale agreement for which he signed a deed, right? And Mr. Becker nowhere, even today, says I meant to borrow $2.24 million and pay it back with interest. He doesn't say that, right? He's not going to say that. What he wants is to sell this house, get $2.2 million, pay off his first mortgage, pocket the money, buy a second $5 million home, and then sell the house again. That's what he wants to do. It's not relief that this court would ever grant, including under the decision of Johnson v. Cherry from the Texas Supreme Court, which is the only case cited by plaintiffs in support of this theory. Okay. Third, I think I've already addressed the imminent harm argument. It doesn't seem like a sale is going forward. For that reason alone, there's no need for a TRO, right? And if Your Honor has questions for me about those details, I'm happy to answer them. I recognize this is a difficult position for Your Honor to be in without unfolding in real time factually. But fourth, let's talk about the balance of equities, which Your Honor would have to determine if you're going to grant a TRO this morning. We have put before you evidence, just like we did on the third expungement hearing, that every month UpEquity is forced to hold this home, and it sits unjustifiably encumbered, results in about $70,000 of costs. UpEquity is paying interest on the money it used to purchase this property. This is why plaintiff has locked up this house through improper means. Secret lis pendens, improper lis pendens. Lis pendens filed the business day after they're expunged, and now temporary injunctions. He knows that once this house is sold, his contractual right to cover a deficit, which I expect to happen, is going to kick in. Plaintiff can't have this house sold because that's going to trigger liability for him under the trade-up agreement. So it's his goal to keep this house frozen, not because he signed a mortgage called a deed, not because he has a real estate interest in the property, but because if he doesn't, he's going to face a claim. And that's why this is before Your Honor. That explains all the history of this case. If Brandon Becker wanted to have a temporary injunction put in place, he filed this case in 2023. It's not abnormal for a real estate case to have a preliminary injunction hearing right around the time that the petition is filed. We could have had that argument. He could have come before the court and offered evidence and tried to have this heard on a normal basis. He didn't, because he knew he had a secret lis pendens on file, which we only found out about in August. So I'll get back to the balance of equities because I think I've strayed into other arguments. The balance of equities favors us. We're going to incur costs every day that this house remains unjustifiably encumbered, including if Your Honor enters a TRO. On Brandon Becker's side, the balance of equities must weigh the fact that he's had these claims adjudicated twice. And there's no new evidence being offered. With respect, former employees at UpEquity do not get to tell the court what a loan is under Texas law. Daniel Hernandez doesn't get to tell Your Honor what a loan is. Neither does Matthew Becker. Neither does anyone at UpEquity, by the way. Your Honor is in charge of legal questions and determining the result of legal questions. As we lay out in the papers, the definition of loan is a purely legal question. It arises under Texas Financial Code section 301.002, section A10. It gives the definition of a loan, which is two parts. Is there an advance of money on behalf of the obligor? And then is there an obligation to repay it? Your Honor, there's nothing in the paper showing an advance of money or an obligation to repay it, which is exactly why Judge Cantou Hexel, when faced with this argument, rejected it and found that the third lis pendens should be expunged. With that, I will, of course, take any questions Your Honor has, being mindful of your time, and thank you, Your Honor, for your patience. And I yield the rest of my time.
Okay, thank you. Mr. Natale, you're the movant. You can have a brief final word, and then I might have a question or two.
Thank you, Your Honor. As it pertains, I'm going to start from the balance of the equities. As my co-counsel, my opposing counsel and colleague has clearly stated, if there is going to be any deficiency, that will be claimed against my client. So all of the expenses that they are claiming to occur, they are going to impute it on my client if they're going to win trial. So a brief postponement of this sale by a week causes no harm whatsoever, to the defendants, whereas it would permanently deprive to my client of his ownership interest. Well, let's look at the testimony of the employees who worked on this specific file. Everybody said that UpEquity is not the ultimate buyer. It's not the ultimate buyer of this transaction. And by the way, if UpEquity is going to sell this property on March 31st for $1, my client will be on the hook to pay back the entire $2 million, according to the contractual rights that my opposing counsel was claiming about. So it is a loan, as being characterized, as being described to be a credit agreement. My client retains all of the responsibilities commonly associated, not just with ownership, but also with a loan. I disagree that the last lis pendens hearing The court had a full opportunity to review the head of mortgage affidavit, specifically because Mr. Silvestri objected on the timeliness of that affidavit and requested the exclusion of it. Now, like, there is no timeliness objection regarding that specific affidavit. She was involved at beginning when Apequity built this financial product. Apequity is a mortgage originator, is a mortgage lender, has an NMLS license. And when she raised concerns, they were just like set aside. In her affidavit, it is clearly stated that the title was given as a guarantee, like as in order to guarantee the repayment of the first installment, which are funds that were advanced to my client. My client was charged interest upfront in the called convenience fee. Matt Becker testified that falls within the textbook definition of interest. They are not the ultimate buyers. And we did retain, my client retains ownership interest. And by selling this property, continuing marketing this property, my client is suffering irreparable harm and most likely is going to moot our entire case. The only thing that my client is asking today, Your Honor, is a brief pause. In this way, we can get a temporary injunction or the final hearing. Like, we're going to go to trial on April 7. We're scheduled like on April 7. By April 10, if they win, they sell the property. Otherwise, if we win, we're going to keep the property. And the loan, what my colleague was saying, like, if this is a loan, we are under the obligation to repay, which we are already under right now to repay regardless. Although he doesn't want to call it a loan. It is a loan because we are under the obligation to repay it. Thank you, Your Honor.
All right, counsel, let me ask you, I do see the April 7th trial date. Has the case been mediated?
Your Honor, who are you directing that to?
To me, personally.
Both of you.
Okay.
I will address it, Your Honor. I attempted to mediate. I requested like mediation. Defendants believe to be completely meaningless. Now, like, we are attempting like to schedule mediation after that the court put us like on the bottom of our docket because of this deficiency. We were kind of in agreement like this week that would have included also mediation. Defendants pulled like from that agreement, although I certified that I'm still willing like to stand by like to proceed with mediation because it is a court mandated. Is mandatory by the court that we do mediation. I emailed opposing counsel requesting availability for mediation, and the response was that this is going to be completely meaningless. And honestly, Your Honor, I cannot force anybody to do anything.
Your Honor, may I chime in?
Yes.
Plaintiff has filed a motion to continue the trial. It is up Friday. This trial is probably going to get continued. We were on the precipice of an agreement under Rule 11 to continue the trial. And then the temporary injunction in TRO was filed. And I did email Mr. Natale and say, listen, it was filed at night. I haven't had a chance to confer with my client to see if they're still willing to continue the trial. This is a material change, so I technically withdrew it. But this trial's getting continued. We're 18th on the call. We have not mediated. Mr. Natale's correct. He's also correct that I told him I don't think you can mediate a dispute where both parties feel they're entitled to a piece of real estate. But I would completely respect Your Honor, which is what I expect is behind your question, saying counsel mediation is mandatory and you need to complete it. And we will hold a mediation if required. I think that's all that I would need to add to Mr. Natale's response.
Okay. Well, I just wanted, I believe the docket call is tomorrow for this jury week.
Yes.
And at the docket call, that will be part of what the judge asked. Has the case been mediated? Cases that haven't been mediated and haven't gotten an order from a judge excusing them for mediation, those do not go to trial. More likely than not. I'm not handling the docket call, so you will find out more from Judge Meacham tomorrow about your chances, but if there has not been a motion filed asking to be excused from it and no order granting it, then the fact that you haven't done it probably means you aren't going to trial on the 7th in all likelihood.
Completely agree, Your Honor. And Your Honor, we may even reach agreement to continue it voluntarily for that and other reasons before the docket call.
Okay.
Yes, let me add that in that case, like, the agreement that we were negotiating was going to be like for May 5th. So like in that case, what like the functionality of this procedure would be TRO, like to allow like the temporary injunction to be heard, which will be scheduled within the 14 days. And then we are going to put on like 3 hours evidentiary hearing showing that we are entitled like for a temporary injunction until the end of trial. And still like I believe that the argument and the facts are all the same. Like the balance of the equities favor plaintiff because as defendants counsel has acknowledged, all of those costs are going to be our responsibility if they win. So they're going to pass it through, like, and we have to pay all of those costs regardless that they have claimed that they are hindering them like at this moment.
Okay. Well, we don't need to get into the merits today of things that aren't in front of me, like a TI application or whatever else. But I just wanted to make sure you were aware our local rules require mediation, and you don't get a jury trial if you haven't checked that box. I mean, unless it's a very rare circumstance and you can convince Judge Meacham tomorrow that maybe you are still ready for trial but shouldn't mediate, which maybe you could do, but I'd be surprised.
Message received.
Okay, great. All right, I'm gonna take a closer look. I'll get you an answer before the day is out, and we'll take it from there. But thanks for appearing, and I understood your positions quite well, so I don't need anything else from you. Great. Good afternoon, everyone. Welcome to the 200th. We are here for an emergency hearing in municipal operations versus Ken Paxton and the city of San Antonio. I have read what Ms. Riggs filed and sent us, and why don't you go ahead and introduce yourselves before we get going.
Jennifer Riggs here on behalf of Municipal Operations LLC, and Lauren can speak more directly to it, but we have resolved the issue as to the Attorney General temporarily. So.
Yes, Your Honor. Lauren McGee for Ken Paxton, the Attorney General. And as Ms. Riggs said, just moments before we came on here, we did agree to a temporary injunction with regards to the Attorney General, not to release any documents, which we're already not allowed to release under statute, but not to release any documents until the litigation is over.
Okay, and is that something you are gonna file a Rule 11 or?
Well, we actually have an agreed temporary injunction that addresses just municipal operations and the Attorney General. And I believe my paralegal has just sent the final version, which has the electronic signatures of Ms. McGee and myself on it, to Ms. Seeger. Or she's doing it as we speak.
Okay, and so you are asking the court to go ahead and sign that agreed temporary injunction between the Attorney General and the plaintiff?
Yes, Your Honor. And I believe with respect to the city, we do have, they are not agreeing to a temporary restraining order or a temporary injunction, so we do still need your time for that disputed issue.
Okay. All right, and Ms. McGee, do you want to stay for the remainder of the fight, or do you want to be excused?
I would like to be excused if that's okay, Your Honor.
It's fine with me.
Okay, well, thank you very much for your time. I appreciate it.
You are free to go. Thank you. All right.
And Judge, just because I didn't introduce her, Ms. Gilbert is here. She is the attorney handling the case, the contested case from which the information at issue in this Public Information Act request arose. She signed the affidavit that we submitted with our papers, and I know this is not an evidentiary hearing, but in the event you have questions for her, she is here, should you need to ask her any questions.
Okay, understood. All right, well, it's your motion, so.
Thank you. Basically, it's an open records case. We did get a decision back on Friday, the 21st. We have 10 days under one section to file an appeal of that. We rely on section 552.252 or 352, it's 253 for a right to appeal. And my client has an interest in the underlying information that the Attorney General's office ordered the City of San Antonio to release. And we briefed the issue with the Attorney General's office, and we are seeking this court's review of that information. The Public Information Act sets up a system where you submit the information for in-camera review to the courts under 552.022. The information cannot be discovered except pursuant to a protective order. And in fact, the Act prohibits the Attorney General's office from releasing the information either during the open records decision process or in a lawsuit to challenge the decision, which is why, of course, the Attorney General's office routinely agrees to be enjoined from releasing it. The section at issue for the city is section 552.303, which is set forth in our petition, and it purports to give the governmental body the discretion to release information while a request for an open records decision is pending or while a lawsuit is pending, unless the information is confidential by law. And it's our position that that section is there because in many instances a governmental body has only its own interests at issue. It may be a budget document, it may be something between the city attorney and the mayor. It could be a privileged document. And so the city in that situation, or any governmental body, could easily say, we've changed our mind. We no longer want an attorney general decision. We no longer want to pursue a lawsuit to challenge that attorney general's decision. But when a third party has privacy or proprietary information, such as trade secret or confidential commercial information at issue, it's our position that that is what this section means when it says unless the information is confidential by law. Because otherwise, we'd never have a right to appeal. If the Attorney General's office, as it did in this case, say, nah, we don't think that's confidential, we'd never have a right to challenge that if a governmental body could always release it. So we don't believe the City of San Antonio really has any discretion to release the information because that would deprive us of a right to seek review in court. It would render the subject matter of this lawsuit, very likely render it moot. Now, might be capable of repetition in other cases in the future and evade review because they could always release it before we get a ruling. But it's necessary, in our view, to the court's jurisdiction to prevent the release while the case is pending through the court system. And so we believe we'd be irreparably injured because the information is the subject matter of the lawsuit. We'd be deprived of our appeal. And we believe we can show a probable right, at least to the temporary injunction pending the appeal. Now, our petition goes into detail about all the exceptions we believe apply, but I don't think the court needs to go that far in order to say, hey, this is how it works. We review the information in camera, in fact, the statute says that the information is not subject to Rule 76A. There's a procedure set up for the in-camera review of the information. And I think in our original submission, we sent one of the cases we cite in our petition saying the court has jurisdiction to issue a temporary injunction pending the outcome of the case. And so that's why we're here today, and we're asking the court to tell the city of San Antonio to hold off on releasing it until we have the chance to brief the issue, submit it for in-camera review, and get this court's ruling on it.
All right, Mr. Freeland.
Thank you, Your Honor. Joe Freeland on behalf of the city of San Antonio. I agree with Ms. Riggs' presentation of where we are in this case, and from the city's standpoint, I think we're sort of in a rock and a hard place. I have a mayor who really wants this document released, and I have a city attorney's office that has real qualms about moving forward with releasing what might be a confidential document of a third party. And so, if you go back and look at the way the document was structured, the city never affirmatively recognized that the information in it was confidential. But what we did recognize was that municipal operations was asserting confidentiality with regard to the document, and that we would follow the Open Records Act process with regard to how that works. So we did that. We submitted the information to the third party. We submitted a request for an AG's opinion. And so we waited. We got back last Friday, as Ms. Riggs said, the Attorney General's response to the request and finding that the information was not subject to the exception of the Public Information Act. So at this point, I think the city really is just looking for some guidance as to what to do. If in fact Ms. Riggs is correct and that we legally have no discretion, we would like to know that. And I think we would like to, I haven't been authorized to consent to a temporary injunction. I guess that's sort of the bottom line from the city's standpoint, Your Honor, although I would say we don't have any substantive objection to the information provided in the request for TRO. I'm not going to object or to dispute Ms. Riggs' characterization regarding whether it's confidential, whether release would cause irreparable harm. I don't have any basis to do that. What I will tell Your Honor is I really don't want to place any unnecessary burdens on the court moving forward. And so if you grant the TRO, I will work with Ms. Riggs and the city to see if we can't either join in the agreed temporary injunction that the Attorney General has entered into. I haven't seen the final version of that. Or if nothing else, perhaps we could extend the TRO to match the setting in the agreed TI.
Okay. All right. I think I understand your position. All right, Ms. Riggs. So let me make sure I understand kind of what your game plan is. I think you want a TRO entered and anticipate that at a TI hearing, a judge would review this agreement in camera and make a decision about whether it is or isn't confidential under the statute. Is that what we're talking about?
I think actually that's what happens on the final trial on the merits and the parties set up a briefing schedule. These cases I've had the Attorney General's office tell me before they do not believe open records cases are subject to Chapter 10, but I have had assistant AGs agree to assignments under Rule 2 or Chapter 2, and we then set up a briefing schedule and a time for argument and submission of the documents for in-camera review. So I think we have to get we do have to get our citations. We have to get the parties served. They get to answer, and then we will probably go see if Joe would agree to have the case assigned on general rotation by presiding judge, and then we go forth with a briefing schedule. And I do think we would have to make a temporary injunction with the Attorney General's office valid. I think we do have to have a trial setting since it is a temporary injunction, and we have left a blank for that, but we can work with Joe and with Lauren and go to the court administrator's office and get a date put in. And then, of course, if it's assigned to a particular judge, we'll have to go to that judge and say, by the way, if that's not okay with you, we'll change it. So I think any date will do for the trial, but I don't think it requires. I think what we would have to do at a temporary injunction hearing is say why we're irreparably injured from the release of the information pending that final review. The act doesn't set up that, be nice, but it doesn't set up that quick a resolution.
Understood. Okay. Based on what I have read and what I've heard here, I will grant the TRO. And why don't y'all take some time to confer about the form of that? Go ahead and get the trial date for the TI from the court admin and do all those things. You can send Ms. Seeger what you are ready for me to go ahead and sign and handle.
And for the amount of the bond, on the Attorney General's office, because we're not seeking monetary damages, it's not a money case. We had put in a bond of $500, and we can confer with Joe on that as well. But if you would prefer, Judge, that we leave that blank for your discretion, we're happy to do that as well. Or do you want us to try to reach agreement on the bond as well?
I'd prefer if y'all would take the time to try and
Very good.
agree on it. Yes. The more you can work out, the less there is for me to spend time on. And we are quite inundated with emergencies this week. So anything you can do to minimize that would be great.
Well, then if you will excuse us, we will go confer and get a proposed order to Ms. Seeger.
Yes, that sounds great. All right. Thank you, counsel, for your time.
Oh, and also,
Thank you, Your Honor.
would you remove your hat? It's not proper to have a hat on during, and then you'll need to kind of be still and not be moving around. Thank you.
I'm at work. I'm actually training an employee.
Okay, yeah, you can't be moving around or anything. Okay, the 20th District Court of Travis County is now in session. The Honorable Jessica Mangrum.
Mr. Milton, it is your petition. You may proceed.
Yes, ma'am. We filed this petition for writ of habeas corpus because Mr. Cerda has once again taken the child, is withholding the child, this time in violation of a court order, and also is holding the child out of school. We had an AG hearing on March 7th. Prior to that, he had done the same thing for 34 days. We appeared before Judge Mangrum. Judge Mangrum let him tell his entire story, ordered the child turned back over to
I think you mean Judge
mom.
Morton. You mean Judge Morton?
Oh, yes. What did I say?
You said my name.
Oh, sorry.
I don't think I've seen the parties before.
Yes, Judge Morton, and then ordered the child turned over to the mom immediately, and then took the somewhat extraordinary step of ordering possession for the father, despite there not being a DNA test result back yet, just because of the sort of extraordinary circumstances. Can I share my screen just briefly?
Yes, you may.
Okay, give me just a moment. So here she went ahead and said that he would have the first, third, and fifth Fridays from 6 to 6, Friday to Sunday, and electronic communication every Thursday. Since that time, he's become increasingly histrionic about not being able to do the phone communication whenever he feels like it, and at times emailing once a minute for messaging over and over and over again. So this last Sunday, he decided that he was not going to return the child at all. And so today's Thursday, and since Sunday, to the best of my understanding, He has held the child from mom and has held the child out of school. So let me take off this sharing real quick. With no good basis. I've heard that he's alleging this and that. I don't know that there's any basis for anything he's alleging, but we need the child ordered back into mom's care. We do have another AG hearing on April 16th, but we thought it was unreasonable to ask mom to just put up with this until April 16th, thus this particular filing. And I will be also following up with an enforcement filing so we can get things like makeup time and attorney's fees. But what we're asking the court to do today is just order the child back into mom's possession immediately.
All right. Thank you. All right, Mr. Serta. What do you have to say for yourself?
Hi, Your Honor. I want to first and foremost tell you that I have not disregarded the court order purposely. I've done so in the best interest of my daughter. Immediately upon picking her up, she immediately told me that I was being stalked and I was being watched by a guy, a friend of Rochelle Corona. And she immediately told me after Rochelle dropped her off, she ran to me desperately to share this. She said, "Daddy, somebody is watching you, but you do not know who it is." And I said, "Who is it, baby? What do you mean?" Because she's 5 years old.
Okay,
And
I'm gonna object to hearsay from the child, but
All right.
no,
Mr. Serta. Okay, Mr. Moore, I'll say this is not an evidentiary hearing. This is a quick emergency hearing. So
I understand that. I'm good.
Mr. Serta, the court order is in place for a reason.
right. And my daughter's safety is paramount, is to my utmost important. And and it is not hearsay. We have an open case with
it is hearsay. It's an out of court statement that you want me to take for the truth of the matter. We're not having. I need you to tell me where the child is now.
The child is my baby is with my sister, and I spoke with DPS, Travis County Sheriff's Office, and APD and detectives, and they told me not to turn the child over. She is in danger, and my daughter has expressed that he was touching her inappropriately, and she told her mother told her not to tell me. She said, "Daddy, I tried to call you, but mommy hid my phone from me, so I can't call you," which she did. She violated the order, and I have been trying to, I don't have an attorney, but I'll be filing the motions myself because I have evidence of showing that she violated the communication order on Thursday. I did not get to speak to my daughter, and my daughter has been calling me. Her grandmother was banging on the door, scaring her, and my daughter was on the phone, and they snatched the phone away from my daughter. But what's most important is that my daughter is in danger. She feels she's in danger. She even told CPS that she does not feel safe with Rochelle, her mother, or her grandmother, or Mike. And Mike was, in fact, Mike is this guy that said that he was before they did the drop off on Friday. He met up with Rochelle and told Rochelle that he was going to be watching me, and after I left, he was going to hurt me. And my daughter expressed that. She described him to the very detail. She described his home. She described his vehicle, the color, and also him as well. So she is in immediate danger, and then she began to express to me that Rochelle left her alone with this man, which is a stranger, and that they were playing with money, which is drug money, and it is a drug house where they sell fentanyl. And I had already expressed to the courts on our first custody hearing that Rochelle has her state of mind and her lack of proper, judgment of the interests of our daughter. She is prone to leave her daughters with strange men, and I have witnesses that will come forward and testify on my behalf for my daughter's interests. So it come to find out, my daughter described the house to the T. I can show you. I can screenshot. I can show you. I can screen share my phone with you and show you where witnesses have come forward and told me the same very house that my daughter described is a drug house that Rochelle took her to, left her in, and that's where they distribute and store fentanyl and drug money. I spoke to detectives.
I need to interrupt you because we are here on Ms. Corona's motion. Okay? You don't have a motion pending. So everything that you've told me about, if you feel like there are things you need to bring to the court's attention, you need to file a motion, you need to request a hearing and set it and give notice under the local rules. We are here on Ms. Corona's motion because you are in violation of the current court orders. And you are not even the adjudicated parent of this child. So as it stands, whatever rights you have not been established other than what's set out by Judge Morton's order. You've got two options here. You can return the child, or I can send law enforcement to pick her up. Those are your options. So you need to think about what is in your child's best interest here.
Yes, I am in my daughter's best interest. I had filed a suit and I have did my paternity test. And I understand that they filed the motion before I did. I'm trying to express I'm trying to share with the court that my daughter is in immediate danger. I spoke to the detective. The detective, they ran because they did in fact discover that he was laying in wait exactly the way my daughter explained to me, laying in wait to harm me. And the only reason why we discovered it is because my daughter brought it to my attention. And I had no choice but to bring it to APD's attention. And they told me not to return our daughter under all the circumstances. Under their investigation, they realized that he is a very dangerous suspect. And they're appalled on the decisions that Rochelle Corona has took in leaving our daughter in his presence, in his home, alone. And she was also denying it, but our daughter is on video and has also spoke to CPS and let CPS know herself in her own words that Rochelle left her alone with this man various times at this drug house.
All right, Mr. Moore.
We're aware of no CPS call by Mr. Serta or APD or any CPS inquiry or any contact about any
I
of
have the
this.
cause
If
number
they
if
had
you need
been contacted about this guy being dated, and by the way, this guy, the child knows this man. It's someone who's Miss Corona has been dating for a while. The child knows who he is. He's not dangerous at all. If there's allegations of a drug house or him being dangerous, we would have heard from CPS by this point. I'm finding all this very hard to believe. And none of this, by the way, was raised at the March 7th AG hearing. So I'm pretty mystified by these allegations.
All right,
Because
Mr. Serta,
my daughter did
it's
not
my
know.
courtroom, okay? You
Yes,
need to
ma'am.
listen, all right? It's my time. Back to my question. We're here on the motion that's been filed. It's in front of the court on the emergency basis. Again, you will either return the child or alternatively, I can send law enforcement to get her and return her to the parent who is lawfully entitled to possession. That is the only adjudicated parent. You are not. What is your choice.
I will cooperate like I have with the court, but I want the court to hear me out and hear the extreme concerns that my daughter, the extreme danger that she is. The detectives have expressed that this is one person that they do not want around my child. They've expressed their concern to me. They told me not to return her. They told me I am doing a great job as a father. I'm asking the court to hear me, hear my cries, hear my pleas for my daughter's protection. I can prove everything that I am telling you. My daughter, I'm not the one that brought these concerns up. My daughter is. My 5-year-old daughter is the ones that brought all these alarming concerns. And she told me that Rochelle Corona, her mother, told her not to tell me. After she expressed to her that she was uncomfortable around Mike and that he was touching her and overly affectionate to her, and also talking about me, disrespecting me, and she was forced to defend me. And she's only 5 years old, ma'am, and she's never met him before. Miss Corona is committing perjury to the court. She's has been proven to lie in every courtroom in Travis County.
She has not spoken here today, so there's only
You heard
two
her
people
attorney.
that have spoken here. Mr. Serta, you need to either retain an attorney to represent you or to file a motion if indeed you have information that you want the court to make a decision on. You have nothing in front of the court today. So I can't make any decision based on what you're telling me. Okay? That's for another day. But it sounds like for now you have agreed. So it is 3:20. The child needs to be returned before 5 p.m. today. Are you going to be able to do that? Oh, Mr. Moore?
I was just going to add, they've been exchanging it, and I'm reading from the order, the corner store located at 6,000. So I believe that it would be best that the child be at a given time taken to that same location.
All right, Mr. Serta, I know she is with your sister right now. When do you get off work?
Up to this evening. If you can give me tomorrow morning, I will turn her over.
Absolutely not.
And then I will
You have violated a court order for a second time. If your sister can deliver her to the corner store by 5 p.m. Okay? If not, I'm afraid I will.
Right. I have not violated this.
You need to have the child at the corner store by 5 p.m. today, whether your sister delivers her or you deliver her. If she's not there, I'm going to enter the writ of attachment and we can have law enforcement handle the situation if that is
I understand
the route you seek.
My daughter is in immediate danger in Rochelle Corona's possession. I am expressing that to the court. She is in danger. By me returning my daughter is placing her in danger.
I will repeat, you are not the adjudicated parent of this child, and a court order based on an evidentiary hearing has already been entered, giving you limited access, and you have violated that now, not once, but twice.
I've never violated one time where APD, Travis County Sheriff's Office, told me, and I have their card number, the cause number, to share with the courts. Can I provide it?
Mr. Serta, APD and the Travis County Sheriff do not determine child custody proceedings. Judges do, judges have, and you have ignored twice the order that's in place. So get the child delivered to the store by 5 p.m. today, or we will have law enforcement pick her up. That's it. get a lawyer, file a motion. That's the end of the story. Mr. Moore, anything else?
Yes, I'd like to ask him if his address is still 30. Oh, goodness. Well, looks like he's clicked out.
Yes, I'm not surprised. Okay, so Mr.
Well,
Moore.
I was gonna ask, I wanted to confirm that address. I wanted to get the sister's address, and then I was gonna say, hey, give me that APD in Travis County contact because I want to call him. But he's gone. I guess I'll just have my client go and wait at the store. And I'll let you know if he doesn't show up.
If the child is not there at the store by 5 p.m., send the writ of attachment order and we can go, oh, well, here he might be back. So,
No.
all right, Mr. Zeta.
Sorry about that. We got disconnected.
Can I say something?
Not yet, Ms. Corona. Mr. Moore had asked you a question, I think, Mr. Serta. Did you hear his question?
Yes, I did. I do reside in my same residence. May I make a request that my daughter do not be around this dangerous individual until I establish my own defense. I will retain an attorney. I will retain immediate support for myself and my daughter. She is in immediate danger under Rochelle's possession. I have videos, recordings. My daughter feels she's in danger. She is not safe. Rochelle, even the detectives have expressed to me that Rochelle is involved in with dangerous people, and she's also involved in organized crime.
Okay, Mr. Serta, I think Mr. Moore had another question about either the police report number or whatever.
Yes.
If you
Yeah, I would like to have that. You said that you had APD and Travis County contact information about this, and I'd love to have that because I'll call them and ask them because I've never heard any of this before.
Oh,
So,
but I
you
appreciate
want to
your
provide that to
concern.
me?
Yes, I do. I appreciate your concern, so we can both represent the proper side of law in the best interest of our child and a
You-
child to you.
Do you want to get that to me now, or do you want to email that to me?
I would give it to you now.
Okay.
It is 25-0810-271.
And this is APD or Travis County?
This is Travis County.
Okay. And what is your sister's address?
I don't know her address.
Miss Corona, do you know his sister's address?
Is he talking about his sister? I do know her address, or his sister-in-law, because yesterday his ex-sister-in-law was watching her, and I don't know her address. But how does he not know her address if she's taking care of her?
Are you saying you don't know the exact address, Mr. Serta?
I said I don't. Yeah, I think a lot of people know where people live without knowing the exact address, and that's
And he's
my
not talking about
situation.
his real sister. He's talking about his
What is
friend.
the name of the person that
His,
has?
that's not his real sister.
Okay.
She's my
Mr.
sister.
Serta, what is the name of the person that has the child right now?
Her name is Bernice Cruz.
Did you say Bernice?
Yes.
Bernice Cruz?
Yes.
And Ms. Corona, do you know where Bernice Cruz lives?
I just know she lives in Manor, and that's not his sister. She has a
Okay,
baby with her brother.
Ms. Corona,
I don't know where she lives, just Manor, Texas.
okay, Your Honor, could you perhaps order him to get me that address by email? That would be awesome.
Mr. Serta, if you would provide that by email after the hearing is over. That is an order, not a request.
And then I'm going to have, since he's back, are we
Can
talking
I
about
ask
meeting
them-
there
can I-
at 5,
Your
or does my
Honor,
client need to go there and
Can
wait
I
till
ask
5?
them to, Your Honor, can I make a request that they submit the address to this individual named Mike, where my daughter was left unattended by Rochelle at a drug house? Can she provide that address as well, please? because this is an address that my daughter has been placed in, and it's very important that the court receive this address as well. Please, can you make it court ordered? My daughter described it as a tiny greenhouse with a covering, and it's by the railroad tracks.
All right, Mr. Serta, you don't have a motion set for today. It sounds like you may seek an evidentiary hearing at a later time.
Yeah.
So you can talk to a lawyer about how to conduct discovery and to locate information you need to best represent yourself in the case. I can't do that for you here today. It's not really in front of me. Okay. All right, Mr. Moore, what was the other item?
The sister's or the person's address where the child is now, and well, I guess he gave you the stuff on the case number for Travis County. I'll try to see what I can find out there. Again, we haven't heard about anything about this or CPS. This is all brand new. Oh, the other thing was, are we meeting at 5, or does my client need to go there and just wait until 5? She's fine. She can go wait there till 5. But are we talking about meeting at 5, Mr. Serta? Are you going to have the child there at 5?
She can pick her up from my sister's house. That's fine.
Okay, but she said she didn't know the address. Miss Corona, do you know how to get there? Can you find the place?
I don't know how to get there, but
Oh.
I do have her number.
Well, okay, but not being sure how to get there or if we can reach her by phone, I think it needs to be the corner store. Whether
Right.
it's that person
I don't-
drives, I assume, Mr. Serta, that person has a car and drives.
Yes.
Can that person have the child to the corner store at 5 o'clock?
I don't know her schedule, but I'm sure she would do the best to her ability to cooperate. She's a law-abiding
All right.
individual.
It's really in your best interest, Mr. Serta, to see that she gets there by 5 p.m. today. You really do not want to put your child in a situation where you are involving law enforcement. Okay. So contact her, get it done. All right. And again, other things that you brought up are not in front of the court today because you don't have a motion on file. Anything else, Mr. Moore?
Yeah, thank you.
Okay. All right. So if the child is not returned to the corner store by 5 p.m. today, the writ of attachment will be issued, Mr. Serta.
What does that mean?
That means that I will sign something authorizing law enforcement to come and get your child. You would be better off, everybody in this case would be better off if you simply return her to her mother who has possession per the current orders. Okay? If you can't, you'll learn that you will be much better off if you abide by the court orders. If you think there's a reason to change them, you've got to file a motion, you've got to set a hearing, and you've got to bring evidence to support what you're claiming. That's not for today. That's for another date and time.
Can I, and that day will come very soon. One request, Your Honor, can you ask that Ms. Corona do not leave my child with this individual for her safety, please? If children are really the main concern and their best interest is what's important, I plead with the court to line on the safety for my child with this individual that APD and the Travis County Sheriff's Department has determined a very dangerous person with a long criminal history.
That could only be done after a full evidentiary hearing. We're here today on a brief, expedited emergency hearing. I don't have any evidence to support your request, and it was not a part of the motion set today. So no, I cannot. All
So
right.
my daughter's gonna be back in danger.
You were served, sir, with this suit in November. You've waited this long and still have not gotten an attorney. I suggest you go ahead and do so. If not, you will need to file whatever motions you have on your own. All right, so rulings have been made. You are all excused and free to go. Mr. Moore, if 5 o'clock comes and goes and you don't have the child back with your client, please let us know and the writ will be signed.
Ma'am, she's gonna think this as a win, and she's gonna go to social.
The hearing is over, sir. You're all excused. Goodbye.